Hi, everyone. Naturally, all the stories of inequitable conduct I'm going to tell you, none of them concern me. But I want to just talk to you about areas that patent attorneys sometimes get wrapped around the axle on. There's four specific areas I want to touch on. One is inventorship. One is statutory bars. One is, rule out your level of analysis performed prior to initiating a suit. And the last one is document submission. Order should we go through these? The big thing is, naturally, we all have our obligations to the U.S. Patent and Trademark Office. We have obligations to our clients, and none of us ever want to be answering questions in front of the Office of Enrollment and Discipline. So hopefully, some of the stuff I will say you'll remember, and just please realize that sometimes your obligations almost seem to be compromised, where you're working against competing forces. I know everyone here went to law school or is currently in law school, and you always hear the story about the criminal defendant that asks a lawyer to hide a gun for them and stuff like that. And while less glamorous, patent attorneys are sort of persuaded to do things that you typically want to avoid. You always want to avoid. I guess what I was going to do is we're going to have the question and answer session at the end. But being I'm going to be covering four separate topics, if you have a question while I'm speaking, please feel free to ask, because what I'm going to say is probably going to involve several questions. Let's go through the quick ones first. Inventorship. When naturally any person that contributed to one of the claims of an invention is entitled to be an inventor. They need to be listed as an inventor on a patent application that you file with the U.S. Patent and Trademark Office. And typically that goes smoothly, especially when you're dealing with larger companies, because larger companies typically have IP departments that hash all this stuff out. You get invention disclosure forms that list all the inventors and their addresses and everything. It makes it very, very simple for you. The problem is when you're dealing with smaller companies, and also the problem is when you're dealing with companies that you grew from the seed. Basically, small companies that know you forever, and you have like a very tight relationship with them. While tight relationships are good and personal relationships with clients are good, it also breaks down a barrier in which the clients may be prone to ask you to do something that you wouldn't have been asked to do had you been just a separate entity that performed legal services for them. For example, there have been many, many occasions where I sat down with people and you're talking about inventorship, and you're sitting down with one or two inventors and they're explaining the entire invention to you. And these are very, very technical people, and the invention is a very, very technical invention. It might be a way of phase-shifting data to eliminate harmonic noise or something like that. And then all of a sudden, after you're done, you write the application, you email the application to these two inventors. These two inventors provide you with feedback, and you go back and forth with the case. You prep the case for filing. Your administrative assistant contacts them to get inventorship. And lo and behold, up pops the mystery name. The mystery name that you never heard of, the mystery name that you never spoke to. And this mystery name is the founder of the company or the head of the group. And while sometimes it might be the head of the engineering group where you could actually delude yourself into thinking this person did take part in the invention, sometimes it's a marketing person. It's a person that you know, for lack of a better way of saying it, does not have the technical expertise, because there are no claims that are high level enough that filter out all the high tech that this person could have contributed meaningfully to these claims. And the pressure sometimes is covert, and sometimes it's very overt. Sometimes it is, well, this person needs to be listed on every patent because they're always listed on every one of our patents. So that's a problem. Alternatively, they may tell you that, well, our previous law firm didn't have a problem listing John on every single one of the patents. Or, I'm sure if you won't list John on our patent, there are other law firms that will. So they're basically threatening to pull all the work from you. And does anyone have any idea how you would handle a situation like that? Naturally, you can't do it, because doing something like that will result in you no longer having a reg number, which compromises your ability to feed your family and pay your mortgage. So how do you handle it? How do you handle that? Actually, the discussion's all the same. It starts out with we can't because, and then you have to give a reason. Anyone want to take a quick stab as to what that reason would be? Yeah.
Could you say, if we go ahead and do this and there's improper inventorship, it's the potential that your patent could be invalidated later on in litigation, and it's not serving you any benefit by putting improper inventorship. Because
Absolutely.
you might not be able to get it corrected under 256.
You're 100% right. You just pass the buck. You explain that these rules are in place, and while violating the rule could get me in trouble and violating the rule could get you in trouble, more importantly, as soon as you try to assert this patent against anyone, they're going to have a team of litigators that's going to scrutinize this patent, and they are going to depose John, and they're going to ask John which one of these claims or elements thereof John contributed to. And it's going to be very awkward when it comes out that John did not contribute to this. And typically the way in which it would fall is John would go, well, I was on there because I was told to be on there, and my patent attorney, I told him I wanted to be on there, and the patent attorney told me I could be on there. They didn't tell me I shouldn't be on there. Why should I not be on there? So suddenly all the blame is just slid right across the table at the patent attorney, and you want to avoid that. So the thing is, anytime you start hearing people talking about adding inventors that you do not think should be added, red flags got to go up, and do not leave the room. Just have it on, have it right there. Just talk to them and explain that an invalid patent is utterly, utterly worthless. There's no sense in moving forward with this. And typically, every time I've done that, suddenly they're like, oh, so all the money we're paying you to do this is worthless. They sort of get the idea, and it goes over a lot better than saying, you can't, you're lying, and I refuse to do it. That suddenly doesn't work out well. Let's move on to the second topic. The second topic is the same thing. It concerns statutory bars. I've had clients that, typically smaller clients, don't understand statutory bars. And, you start talking to them, you talk about the invention, and typically they want you to tell them whether or not you believe the invention is protectable subject matter. Sometimes it isn't, but most of the time it is. And then they'll start telling you stories about how wonderful the invention is, and you'll then ask the dreaded question of, when have you disclosed this? Have you disclosed it? Have you disclosed it to anyone? Have you sold it, offered to sell the product, and anything like that? And a lot of times they initially give you an answer that isn't very good. A lot of times the answer is so long ago that there's no real way for them to try to push the envelope. We've been selling it for 6 years. Okay, we can't really do anything here. But a lot of times they'll go, yeah, we disclosed it February of last year. And you'll go, huh, in my calendar there's only 12 months a year. That's 14 months ago. You got a problem. And you explain to them the whole, all the rules associated with when an invention can be disclosed and when you actually have to file. And after you explain that, they miraculously remember that there was an NDA in place, even a verbal NDA, or that disclosure actually did not occur until June, miraculously. They're off by 4 months, and coincidentally, they're now within that 12-month window. And they typically just blurt this out, and they'll look at each other and they'll go, hey, Cindy, wasn't that trade show actually June? Yes, I think it was. Good. Oh, you know what? We're fine. And they try to move on real quickly. Same scenario. You handle it the same exact way. And you need to explain that I'm not doubting you, but if there's any emails, writings, plane tickets, scribbles on cocktail napkins, expense receipts that show that you disclosed this more than 1 year ago from today, you got a problem. You're wasting your money. If you want to pay me to do something that's worthless, that's fine. But wasting your money, you're not gonna get a patent here, this patent will be invalidated. And typically they think it through and they realize that we have to move on. Now, there may be a Band-Aid fix that you could put on that. Anyone wanna throw out a possible Band-Aid fix for fixing that one? Yeah.
They create an improvement on the original invention?
You got it. I love talking at this school because people actually know their stuff. But the thing is, that's the big thing. You might find out after talking to them that they disclosed the beta. And the beta version didn't have element D. But the actual, the actual product now has element D, which element D is indispensable. Therefore, you file a claim. While A, B, and C might have been disclosed, D wasn't disclosed. Therefore, all the elements of the claim were not disclosed prior to 1 year. Before the filing, you're okay, you can move on. But the thing is, just keep this in mind. This happens all the time with me, where people, and it's funny because even the people that I hire, they come in and they're like, something strange happened at the inventor interview today. And sure enough, they go through this exact story, where somebody took a disclosure, they asked when it was disclosed, they told them, they're very interested in protecting this technology in Europe and the Pacific Rim, and when they tested it out 3 months ago, it worked great. You're like, oh. And actually, most foreign countries, not all foreign countries, have an absolute novelty requirement. So you have to have a filing date that predates your public disclosure. And when you explain that to them, the client miraculously remembers that the disclosure didn't occur, or the disclosure was under a verbal NDA, or something like that. So always the way to move forward is just explaining that a worthless patent is indeed. An invalid patent is worthless. Now, there's a couple more dicey ones that come up. We are currently handling a litigation for one of my clients in Florida. And we got sued for infringing a utility patent. And any one of you in this room could determine that we do not infringe this patent in about 4 minutes, just looking at it. There's nothing even close in what we're doing versus what we're getting sued on. And naturally there's the face I put on when I'm talking to them, this is ridiculous, blah, 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 blah. And there's, what I'm telling you now is the truth. There was nothing there. It was one of those things where we're looking at the complaint and we're like, how is this possible that we got sued on this? And the interesting part was they really doubled down on their suit because they moved for a preliminary injunction motion, okay? And then after they moved for a preliminary injunction motion, they filed a motion for expedited discovery. And in the motion for expedited discovery, they asked to receive one of the products that we produce that allegedly infringes their patent. Now, the interesting part about this product is that this product was only disclosed at a trade show, and it was in a display that was not accessible to the general public, and all the stuff that would have infringed would have been inside the product. So you can't look at it and go, it wasn't like a light bulb where you look and you go, look at that screw base, glass bubble, I see something that looks like a filament, yeah, we got infringement. No, it's a rifle, it's a rifle. And all the stuff that they sued us on was based on the inner workings of the rifle, which you can't see from the outside of the rifle, obviously. But yet, they knew enough to sue us, and then they filed motions for expedited discovery saying that they needed a copy of the rifle produced in their offices so they could examine it to investigate infringement. Now, you're supposed to do this analysis. It's called the Rule 11 analysis because you need to do it so you don't get Rule 11 sanctions. You're supposed to do this level of analysis prior to filing suit. So does everyone know what a claims chart is? Not all at once. A claims chart is where it's basically a table, and on the one side you'll have each and every element of your claim broke down to whatever level of granularity you want it to be broken down to. And on the right side of the table, you will have text, photographs, drawings of the allegedly infringing product. So if you claim a system comprising a lever. You might have some text in here from one of their manuals that talks about a lever. You might have a drawing that shows a lever, and then you go on to the next element, which might be a fastening device, and then you'll have a photograph of a screw on the device. So what happens is it's basically a map that says, look, we know what's covered in our patent, and we know the elements of the allegedly infringing component, how they map. You might actually have a third column in there that shows what a fastener means in light of your specs. You might have a portion of your own spec in there that says, when we claim a fastener, we mean this, and here's the equivalent structure that they're doing. These people did none of this, and they got so spanked at the hearing for not doing this stuff. They got beaten up, really, really beaten up. And actually, we're all giddy, because now we're going to file a Rule 11 motion for Rule 11 sanctions against them. We're going to move for cost, saying it's a frivolous suit. So it's wonderful. But the thing is, the last thing you need is, it's bad enough if when clients come to you about suing someone, they always ask you, do you think we should sue? Do you think we could win? So presumably, this client did this with this attorney, and the attorney said yes. And then not only it doesn't appear they're going to go down in flames, but they got verbally reprimanded in the court, in an open court. They're most likely going to have to pay, they're going to get sanctioned. They're going to have to pay our costs. And they're going to lose. And this is never a good thing for client relations. And naturally, the first thing that the client starts to think is, why did I pay this guy? Could I have done better with another law firm? The attorney really dropped the ball here, because now the client's bitter. And whose fault is it? Your fault. So the thing is, you always want to make sure you never have the sanctioning end of a stick, and especially when a judge reprimands you in front of the client, because the client was sitting there while the judge was beating up the lawyer for doing this. So you gotta make sure you do the proper level of analysis before you file suit. It's paramount importance. And any questions? Nothing? Okay. And the last topic is document submission. We all know we have Rule 56 obligations to submit any material that we know of that is material to the patentability of your invention. And clients are amazing sometimes in that even though you tell the client, you don't have to search, you're under no obligation to search. They're under an obligation to submit whatever they have, but they're not under an obligation to search for whatever they don't have. But yet clients take it upon themselves to search. And then clients take it upon themselves to send you search strings with silly things in emails that say, hey, I found these 120 references. They all seem to be right on point. Please let me know what you think. Now, what do you do there? How do you handle that? I'm going to call on someone if somebody doesn't raise their hand. Do we submit them all? Do we go through them and analyze them? Give me a guess.
Get a summer intern?
Well, then that means if somebody ever tried to invalidate the patent, your defense would be, I didn't do it, the summer intern did it. Because the thing is, now you're in a very, very awkward situation. You have a stupid email by any yardstick from a client that basically says the whole world is prior art for their patent. And now you're going to be the attorney that's going to lead. I mean, I've had clients do this with 400 references. That's the record, 424 references. A list of 424 references that these all seem to be right on point. So now, if I took it upon myself to be stupid enough to go through these references and deem which ones were and which ones weren't material, I'm holding myself out as being more knowledgeable of what the inventive concept is than the client, which never really works out well. And naturally, who knows what the first thing you try to do when a client of yours gets sued for patent infringement. First things you do dig into the application that they're suing you on for silly things. Clients of mine have been sued for patents that were expired because the client never paid the maintenance fees. So that's always a nice, simple one to dismiss that case. But the thing is, there are many, many times when you try after discovery naturally, you look for the smoking gun email, the 424 patents or references that were submitted to the attorney, and the attorney took it upon himself to submit 14 of them to the USPTO because the attorney deemed 14 of them to be material. And then one of the best things that you do is you go through the remaining 410 references and you look for one little piece in those 9 billion words of text in those references that actually is pretty on point to what your invention is. Pretty on point. So then you explain to the judge or the jury the way in which, of these 424 references, they only took it upon themselves to submit 14 of them, and miraculously reference number 389 concerns this one, it has this one piece in here that is dead on point. And you'll have to read it, they'll have you read it, and it'll be pretty close to what you guys do, but for some reason it's not what you guys do, but it makes you look really, really, really bad. It makes you look like you were trying to hide something. And as soon as you look like you were trying to hide something, you've got a problem. Because now the burden shifts, you're on the defensive, and you have to explain, no, I wasn't hiding it. I wasn't hiding it. I drew a line in the sand as to what I deemed to be material, and what I deemed to be material was X, and this unfortunately fell into the Y category, not material. And then they're going to start going through many, many, many things. And they're going to ask you to look at that one little portion of the reference again and explain why, even though it has so many words that are dead on point concerning your invention, why you deemed this one to be not material. And the interesting part is they will always say that the reason you deemed it to be non-material was because of the fact that it was very, very damaging to your ability to get a patent. So when we get piles of references, as much as sometimes the USPTO objects to it, we submit them all. We never want to be at the accusing end of that stick, where somebody is saying we hid references. And we've submitted hundreds of references. We had the USPTO remind us of our obligations to not bury references in huge piles of references. Because the PTO does get mad if you didn't, because you could get one relevant reference and submit 20,000 other references. And therefore, hey, you know what? Look, I submitted it. You guys just didn't catch it. It's my obligation to give it to you. You didn't catch it. So naturally, you never want to do that. You never want to try to hide something, but it is our policy, and it's the policy of my colleagues over at Fish and Richardson, the policy of my colleagues over at McDermott, Law and Emery, to make sure you submit everything. You want to be able to use the Nuremberg defense. Does everyone know what that means? I was following orders. It came into me, it went out the door to the USPTO. As soon as you become a filter, the way in which you filter is going to be subject to depositions, and you're going to be asked very friendly questions such as, why did you choose to conceal this reference in violation of 56? So you want to avoid that. You want to avoid that at all costs. So just please make it a policy to hugely monitor your document submission policies, because there are so many times that references are embedded in email. You'll see references to papers that are in invention disclosures. You'll see references to patent numbers, maybe U.S. patent numbers, foreign patent numbers, publications, trade journal articles, crazy scribbles on cocktail napkins. But just make sure you diligently, either you or someone on your team, diligently researches what's in a disclosure. Make sure you get everything. Because if there's one thing that is certain in life, whatever you accidentally do not submit, the opposing counsel will argue that you intentionally did not submit it, and that it was dead on material to the patentability invention, and therefore your invention, your patent was obtained through fraud. And when you obtain a patent through fraud, do we all know what happens?
Goes away.
It goes away. And when the patent goes away, what happens to the lawsuit? goes away. And what happens to the $12 million in damages that the client was intending to recover? Goes away. And what might happen to your reg number? It might go away. So the thing is, these are areas that are really, really sticky. Yeah.
And what do you do on the flip side? You get the million references, you submit them to the office, you get the patent at the end of the day, then you get sued for burying the patent, like inequitable conduct because you buried the patent office, they didn't see all the
It
references.
is much harder to get sued for burying a reference, because that really isn't, that's a burden that they have to hit. They have to prove that. Versus, it's much more subjective as to whether you buried something than objective as to whether or not you submitted it. If it's not on an IDS, it is not submitted. So now they just have to subjectively show that you, that was a material reference. And so that's the thing. There's one objective and one subjective. If you don't submit something, there's two subjectives. If they'd have to first insinuate and prove that you buried it, and then they'd have to also show that it was material. So it's just always err on the side of submission. And the thing is, there are times when I've received boxes of references from third parties, and I got to admit that I've been the sender of boxes of references that I submitted to third parties, which naturally, if you're filing a patent and prosecuting it, and you represent my client's competitor, and my client goes, I know that patent of theirs is garbage because of these references. It didn't issue yet, so you can't do a re-exam. However, you could give it to me and I could mail it to you. Hey, I figured you might be interested in these references. Yeah, and a lot of times you don't mail, like I wouldn't directly mail it to you. I'd have my buddy from law school mail it to you, so they don't know where it came from. But they just suddenly got this box of references. I assume you'll be submitting these to the USPTO. I'll monitor the situation accordingly. And that's it. And it's like, ugh. So the thing is, then you just keep looking at the public pair to see if they actually were submitted. But the thing is, there's a lot of games that attorneys play. Surprise, surprise. That you have to watch out for, and you never, ever want to be accused of not submitting a reference.
If that patent gets invalidated
Yep.
because you didn't submit all the references you had, can
Yep.
you be sued for malpractice then and
Oh yeah.
damages?
Oh yeah.
recovered?
Yeah. Because the bottom line is, no matter whose fault it is that the reference didn't get submitted, go out on a limb. Whose fault is it? It's yours. And we're all lawyers. We all have to service our clients, of course. But you have to institute a set of best practices on your part or your firm's part to make sure you don't get sued. Because silliness, sloppiness, however you want to think of it, could result in you getting sued. Yeah.
Back to inventorship.
Yes.
Is it inequitable conduct to not list a proper inventor? Say that there's like a non-compete that the actual inventor is dealing with from a prior job or something, and that still governs.
You have to list proper inventorship for things in your patent.
So you can't
Simply
omit.
because there's some business reason that you did not want to do it? No.
Okay.
You have to submit. I mean, because improper inventorship will invalidate a patent. So you have to submit it. And I'm in a situation right now that I don't know how I'm going to resolve. One of my clients, big client, got a publication under NDA, and I need to submit it to the USPTO. How do I do that? It's under NDA, and it's one of those really horrible NDAs that defines, while it's clear, it would be both parties acknowledge that it would be difficult to calculate damages. We're evaluating the damages at this, and it's a nice, large, six-figure number that now I don't know what to do. I don't know what to do, and we haven't gotten an office action yet, so we're okay. But I have to figure it out. And this is one of those things where you have a business issue, an unexecuted NDA, and damages in the tune of $600,000, competing with your obligation to submit a reference. And the thing is this reference material to the point that it'll prevent us from getting a patent? No. But is this reference the foundation of what we filed something on? Oh yeah, it is. And there's no way with a straight face you could ever argue that this was not material. It is. And we're novel over it. We're novel and non-obvious over it, but it doesn't matter. It's still material, and I have an obligation to submit it. So the good part is the in-house counsel's on IP counsel. So I go, you figure it out. You know the rules. You let me know what you want me to do. Well, they're the ones making the decision. I'm not going to, needless to say, I'm not going to, I'm not going to do anything until I get their blessing. Yeah.
I have two questions. One is, if you get a list of references, like 400 references, do you need your client's prior permission before you engage in all those hours of research?
Well, hours in researching what?
In seeing if those references, how the client's invention overcomes those.
Well, according to Brian's rule, you don't do the analysis. The only analysis you do is making sure your paralegal properly types all those numbers into the IDS form. You engage in the analysis. That analysis better result in one thing, all of them being submitted. Now this is something that everyone has a different opinion. I know good attorneys that go, oh, no, I analyze them. I also know one good attorney that really, really, really got in trouble because they had, shall we say, sort of a shaded level of analysis concerning a certain reference. And the patent subsequently got invalidated, and the client was really, really, really mad because the client immediately took the position of, I never told you not to submit this. Had you submitted it, we could have amended the claims to define around it, but you chose not to submit it, meaning we didn't amend the claims, and we had claims that blah, blah, blah. Yeah, it was great. Anyone else?
It's about time.
Yeah, it's about time. Everyone's got to get to class.
Well, thanks, Brian, for.
Pleasure.
Talking.